Great. Thanks very much, Michael, and good morning, everyone. So this morning I've got the task, really the boring bit, to sort of set out how we got to here before these two interesting decisions that these gentlemen have been involved in. So I'll step through some of the evolution of the code over the last 20-odd years and some of the early judicial observations about the code before the Doggett and Rose decisions, and also look at some of the key provisions of the code. And then Chris and Simon will talk in more detail about the matters which they've been involved in. The Australian Bankers Association website contains downloadable copies of the various versions of the code, and helpfully it also has a list of the dates on which each of the banks adopted them, save for 93, where they don't seem to have that information. It got grafted over from some ASIC website, and so you can't get any specific dates. But besides that, it's got a fairly comprehensive timetable of when all the major banks adopted the various codes. So if you're acting for a guarantor, this will assist you in determining which code applies to the bank that's chasing your client. When I looked at the website this week, I noted that there is currently an independent review of the code, or of the 2013 code, that's underway, and in fact public submissions closed yesterday. Query what will come of the review, especially in light of the recent decisions that will be discussed by Chris and Simon. But when we were planning this seminar, the reality is that the code is a marketing document, and so tinkering with it in any way that overtly improves the bank's position to the detriment of its customers would, on any view, be very risky from a PR point of view. My own view, for what it's worth, is that in light of recent events, the banks are far more likely to do, if they're not doing it already, to tighten up their internal policies and procedures so as to make jolly sure that their employees are complying with the code. I was involved in a matter recently which is probably a good example of that. It was actually a more regional outpost of a bank, and it was the more country scenario where the bank manager is a sort of pillar of the town, and came out and had a cup of tea and a scone, and sort of quickly got the wife of a husband director to execute a guarantee, and off we went. And things are a lot more informally done, I think, the further away you get from major centres. And I think that's probably one area where the banks might be concerned, and certainly that was something that we used to our advantage in negotiating a pretty good outcome of that case for my client. Added to which she probably had a reasonably good Garcia defence, but the failure of the bank to really adhere to its own policies in that regard, in that setting, was helpful to us. I'll take you through. I don't say it's all of the early decisions, but some of the early judicial observations. I'll give you a potted summary of those pre-Doggett and Rose. And the first case to note is Sam Management Services and Bank of Western Australia. And in that case, Justice Rain found that the code applied, and moreover that the clause in question, which is clause 2.2 of the, I think the 2004 code, applied as an express term of the loan agreement. Ultimately, His Honour found that the bank had not breached the clause, but quite early on, that was one judge who had no difficulty finding it went so far as being an express term. It went on appeal, and Sam Management Services was unsuccessful in that appeal. However, Justice Young made some very astute and somewhat entertaining remarks. His Honour observed, "This appeal has been made viable because of the inclusion in the contract between the parties of the Code of Banking Practice, a document which was probably never prepared by its drafters to form part of a legal document. It's drafted as a layperson's document to be understood in a quick reading by a person considering dealing with a bank. It thus lacks the precision that one would expect in a term to be included in a contract dealing with megadollars. The relevant clause in the Code of Practice is 2.2, which provides," and I should note here, this featured in some of the earlier cases. It's what I call the warm and fuzzy promise. 2.2 says, "We will act fairly and reasonably towards you in a consistent and ethical manner. In doing so, we will consider your conduct, our conduct, and the contract before us." His Honour went on, "The clause in a legal document is so fraught with ambiguity. Its exact meaning was not canvassed before us. so that it would be unwise to attempt to be definitive in its construction. Assuming it must be given some meaning in a commercial document, it probably does not operate beyond requiring the bank to act in good faith towards the customer. However, the principal purpose of these remarks is to suggest to bankers that the cross-reference in legal documents to their promotional material is likely to lead to complications in litigation. Now, His Honour has proved to be somewhat of a soothsayer because, as we've seen in recent years, the Code has certainly caused its fair share of complications. The next case is Victor Cito and others and the Bank of Western Australia, and there the bank had appointed receivers over 2 hotel businesses and the real property on which those businesses were conducted. And relying on the Code, again principally the warm and fuzzy provision in the 2004 Code, to act fairly and reasonably towards them in a consistent and ethical manner, the plaintiffs sought an interlocutory injunction compelling the receivers to hand over possession of the properties. And in dismissing the application, Justice Nicholas observed that, as Clause 1.1 states, the Code is a voluntary code of conduct which sets standards for good banking practice to be followed when dealing with individuals and small business customers. Clause 2.2 imposes a standard of behaviour in acting towards the customer which is fair and reasonable, consistent and ethical. In doing so, consideration is to be given to the conduct of both the customer and the bank and the contractual arrangements between them. Clause 2.3 states that the bank's key commitments to the customer, which include the commitments under Clause 2.2, regard will be had to the bank's prudential obligations. So these clauses are sort of motherhood type statements, but they were used in a lot of the early cases, I think, without having descended into every line of reading those judgments, probably because they didn't have anything better to run with. And some of those provisions are thought to be somewhat aligned with notions of unconscionability and so forth. His Honour continued, these provisions impose standards of behaviour to be observed in the performance of contractual rights and obligations, including the exercise of contractual powers. The unambiguous language of Clause 2.2 and 2.3 shows that the manner in which the bank is required to act in the performance of a contract with a customer is to be ascertained with regard to the conduct of the parties in the context of their contractual arrangements. His Honour goes on, the effect of the provision, in my opinion, is to preserve the bank's entitlement to act with careful regard to its own interests under the relevant contracts. Accordingly, in my opinion, adherence to the Code does not require the bank to subordinate its own interests to those of the customer or to prefer the interests of the customer. The clause indicates the bank's commitment to have due regard to the interests of both parties in the course of the performance of the terms of the relevant contract. They are directed to the manner of exercise of a contractual right or power. They do not operate to qualify or vary such right or power. So a slightly different analysis there. And then we look at some further decisions. Now, in the Brighton and ANZ case, the New South Wales Court of Appeal appeared to accept that the Code was incorporated by reference into the terms of the guarantee. And then shortly after that, in the South Australian Supreme Court, in the decision of Commonwealth Bank and Stars, Justice Peake made some further observations. And His Honour said, although I find the Code does not apply in the present case, I'll make some brief alternate observations should I be correct in that finding. The position of the defendants was never refined, but it was of the flavour that a breach or group of breaches, ipso facto, wholly invalidates the guarantee. It is sufficient for present purposes to indicate that my view is that it clearly cannot be taken to be the intention of the parties to a guarantee of the sort that a breach of a provision or even a number of provisions of the Code will necessarily have that effect. To take an extreme but nevertheless useful example, it cannot reasonably be suggested that it is to be taken to be the intention of the parties that a guarantee for millions of dollars given by a mature, hardened entrepreneur, experienced with all aspects of the law and practice regarding guarantees, will be nullified upon him later establishing that he was not provided with various information packages designed for novices, or that he was presented with the guarantee directly by the debtor, a person who could never have overawed him, or that various other transgressions of the Code occurred, none of which transgressions could have produced a different result than would have occurred had the Code been scrupulously followed. His Honour continued, in my view, the Code is largely a collection of do's and don'ts for bankers' conduct. And His Honour then links that back to the decisions in Amadio and in Garcia, and forms the view that really, in essence, His Honour's view was it was a way to acknowledge the defences that can be raised by guarantors under those provisions, and in a sense to put guarantors on notice if they were particularly unsophisticated people that they might have defences that exist. But it really didn't go much further than that. And then in Bank of Western Australia and Abdul, Justice Croft observed that, "I accept that the Code of Banking Practice does not, in the present circumstances, have any contractual force. However, in that case, the code wasn't really the main battleground, and the second defendant, Mrs Abdul, succeeded on a Garcia defence. So, again, the code was pleaded, it was run, I don't think extensively, it wasn't front and centre, but certainly on the facts before him, Justice Croft was of the view it didn't have contractual force.